If you're working on a distribution deal for your independent film, one of the things that a potential distributor or insurer is going to want to know is how likely you are to be sued based on the content of your film. I've talked elsewhere about lawsuits against filmmakers for alleged violations of intellectual property rights and how to avoid those and convince your distributor or your insurer that that's unlikely to happen to you. In this video, I'm going to talk about another type of claim or legal theory that distributors and insurers tend to be concerned about, which is called defamation. Defamation essentially means a false statement about somebody that is harmful to their reputation. I'm simplifying this definition, and I'm going to oversimplify some of the legal concepts around defamation as well to avoid making this into a 6-hour discussion, because defamation is kind of a nuanced area of the law. But hopefully I'm going to give you the information that you need for the purposes of planning the making and release of your film. Even though statistically it's unlikely that someone is going to see your independent film and decide to sue you for defamation, like I mentioned, distributors and insurers are concerned about the possibility that that would happen. If your distributor sees your film and thinks there are statements in the film that could potentially give rise to defamation liability, they may want you to get broader and more expensive E&O or errors and omissions insurance coverage than they otherwise would have required you to get. Or you could be dealing with an insurer and the underwriter watches the film and they say, well, we're only going to be able to give you errors and omissions insurance at a higher premium than you otherwise would have paid, because we're concerned about the possibility that somebody might see the film and say, hey, this film makes false statements about me, and file a lawsuit. Or they may require you to hire a lawyer to write them a letter saying, I don't think that there is a significant risk of defamation liability when it comes to this film. Usually independent filmmakers have already made their films by the time they get around to talking to distributors and insurers, and this kind of defamation issue comes up. And so at that point, it's going to be too late to make changes to the film to get rid of potentially defamatory content, short of doing expensive reshoots or edits that may ruin the continuity of the film or something like that. So the earlier in the process you are, when you start thinking about potential defamation liability and intellectual property liability and so forth, the better from a cost perspective. So before I get into some tips for avoiding defamation liability with your film, I need to make a couple of disclaimers, because we lawyers, we just can't resist, disclaiming things. The first disclaimer is that I'm going to be talking primarily about United States law. So if you made your film or you're going to be distributing your film outside of the United States, other very different legal rules may apply to defamation claims, which you'll need to look into. The other disclaimer is my usual one, which is that I'm not going to be giving you legal advice, because if I were going to give you legal advice, I would need to understand your specific situation and your specific needs. But right now, I'm just a lawyer talking to you on the internet. So with all that said, let's talk about defamation. Like I said, defamation is a false statement that is harmful to somebody's reputation. I'm going to make 7 points about defamation that I think are going to be potentially useful to you as a filmmaker. The first thing that I'm going to talk about is the fact that defamation doesn't only apply to documentary films. You may think that you're not at risk for being sued for defamation if you're making a narrative film, if you're making a work of fiction, rather than a documentary film. But that's not necessarily true. In fact, there have been many published legal cases in which a famous person sued the studio that made a narrative film or a narrative TV show that they were depicted in. I talked in a recent video about a suit by the actress Olivia de Havilland, who sued Netflix based on the way that she was depicted in the Netflix show Feud, Betty and Joan. Among other things, de Havilland is depicted in the series as having called her sister a quote-unquote bitch, when in fact she called her a dragon lady. And that was one of the reasons why she said that the show was defamatory. Olivia de Havilland lost that lawsuit, but having to defend any kind of lawsuit can, of course, be expensive and time-consuming even if you win. It may also be possible to get sued for defamation based on a work of fiction if a character in your film isn't named after a real person, but shares a lot of similar characteristics with them. There was a defamation case in Georgia about a novel written by the author Haywood Smith. And in that book, there was a fictional character who very closely resembled the plaintiff in, I think that the court said something like 20 ways. They had the same hair color, they were both chronically late, they were both chain smokers, they both had traumatic childhood experiences and so forth. And that was enough evidence for the court to say, I'm going to allow the jury to hear the claim that this novel, even though it was a work of fiction, defamed this real person who claims to resemble a character in your book. The second point I want to make is that true statements can't be defamatory. Here's one of the most basic points about defamation. The fact that someone doesn't like a statement that you made, or even if the statement is harmful to their reputation, doesn't necessarily mean they can sue for defamation. The statement has to be false in order to be defamatory. In fact, the statement doesn't even have to be 100% true in every detail and every particular to avoid defamation liability. It only needs to be what's called substantially true. There was an example of this recently in an ugly lawsuit by an ex-girlfriend of the boxer Floyd Mayweather. She sued Mayweather for saying on a radio show that she'd had plastic surgery all over her body, including on her face. This statement was defamatory, she claimed, because it was harmful to her reputation to suggest that she'd gotten a facelift, essentially. But the fact was that she did have plastic surgery done on other parts of her body. And so Mayweather's statement that his ex-girlfriend had had plastic surgery all over her body was substantially true. The gist of it was true, and therefore it was not defamatory. So if you ensure that the statements that you make in your film are truthful, or at least that the gist of them is true, that can help protect you against defamation liability. The next point I want to make is that opinions aren't defamatory. To be defamatory, something that is said in a film needs to be a statement of fact, rather than a statement of opinion. What is a statement of fact? At a high level, it means a statement that you could disprove with evidence, while an opinion is a statement that could not be disproven with evidence. For example, there was another highly publicized defamation lawsuit by the actress Elke Sommer against another well-known actress, Zsa Zsa Gabor, based on Gabor's alleged statements that Sommer was broke and had to sell her house in Hollywood and hangs out in seedy bars. Gabor claimed that this was a statement of opinion because whether Sommer was broke and hung out in seedy bars was a matter of subjective judgment. But the court disagreed because those statements were capable of being proven false. Sommer could theoretically have proven that she wasn't broke by submitting her bank records to the court as evidence, for instance. So because it could be disproven, it was considered to be a statement of fact for the purposes of defamation. But here's an example of a case where the statement was not disprovable, so it was considered opinion. Johnny Cochran, who famously represented O.J. Simpson, sued the New York Post for saying that Cochran, quote unquote, will say or do just about anything to win, typically at the expense of the truth. The court held that this was a statement of opinion because it wasn't disprovable. The basic question was, how would you prove that Cochran didn't say or do just about anything to win? If the newspaper had accused Cochran of lying about some specific fact or event, he may have had a better case, but the statement was too vague to be capable of being disproven, and therefore it was considered to be opinion and not defamatory. Sometimes a statement can also be considered opinion if the average person reading it wouldn't take it literally. So here's another recent example. There was a famous case where the stuntman Evel Knievel sued ESPN based on ESPN's statement on its website that Knievel, quote unquote, proves you're never too old to be a pimp. Knievel said that was defamatory because he wasn't a pimp, in the sense that he didn't, facilitate transactions between prostitutes and their customers. The court said that that was a statement of opinion because no reasonable person, no average person, would read that statement and think that they were actually saying that Evel Knievel was a pimp in the prostitution sense. Let's talk about point number 4, which is that films about quote-unquote public figures are more likely to be protected against defamation liability. When you make an allegedly defamatory statement about someone who is considered a public figure, the public figure, in order to sue you successfully, has to prove that you made the statement with what's known as actual malice. What is a public figure? It's someone who has voluntarily or involuntarily acquired some degree of fame, whether it's an actor or a politician or a musician or someone else. This is a plus from the perspective of filmmakers because when they're making a film about a real-life person, they tend to choose someone who's famous, who's had a big impact on the world and who people know about. So, like I said, if a public figure sues you for defamation, they have to show that you made the statement that they object to with actual malice. What does actual malice mean? From the way it sounds, you would think that it means that you hate them or you bear them some kind of ill will, but that's actually not what it means. It means that you made the statement with reckless disregard for the truth. In other words, you either knew that the statement was false, or you failed to do the most basic investigation into whether it was accurate. What's a good example of a plaintiff who failed to show actual malice? About 20 years ago, the National Enquirer published a piece claiming that the actress Mimi Rogers trashed a green room at the Home Shopping Network. Rogers sued the newspaper for defamation, but it turned out that the National Enquirer had actually done its homework. It had acquired a lot of internal documents that suggested that something happened resembling the incident that it described. So, at the very least, Rogers wasn't able to show that the Enquirer failed to investigate the statement it made about her trashing the green room before it published the article, and so she wasn't able to show actual malice. Now, even if the person who is suing you is not a public figure, they would still have to show that you made the statement that they're challenging in the lawsuit with at least negligence, that is, with at least a failure to use reasonable care to ensure that the statement was true, which is better than nothing. Anyway, the moral of the story is thoroughly investigate any statements, any claims that you're going to be making about the subjects of your film that can help you protect yourself against defamation liability. Where possible, document your research. In other words, if you find articles about the person you're making the film about one of the subjects of your film, then make sure to download those articles and save them so that in the very unfortunate circumstance that there's litigation or some kind of dispute, you can use those as evidence that you did your due diligence. Number 5, get written consent wherever possible. Whenever possible, you should get written consent from anyone who appears in your film saying that you have permission to use all of the footage that you shoot of them for any purpose that relates to the film. This is a good precaution to take against potential defamation claims. This type of clause, which I've talked about before on this channel, is an essential part of every contract with anyone who's appeared on the set of your film. Usually, as a practical matter, this is going to be more important in the context of a documentary than a narrative film or a work of fiction. Actors in a narrative film usually won't be interested in suing you for defamation based on the acting they do in your movie. That wouldn't really make any sense. But people who appear in a documentary after they see the final product of the film with all of the edits and so forth might come to feel that the film doesn't portray them accurately or it portrays them in an unflattering light. And that's something that can give rise to potential defamation litigation. Of course, getting the consent of people who don't voluntarily appear in your film usually is hard to do, as they don't have much of an incentive or much of a reason to waive their right to file a defamation lawsuit against you. In the Olivia de Havilland case that we talked about earlier, Netflix, of course, didn't have de Havilland's written consent to the script of the TV series that she was depicted in and the content of the show. And even if they had asked her for that consent, it probably would have been impossible to get. Point number 6, deceased people's estates can't sue for defamation. If you do a documentary or a narrative film about someone who has died, they're not going to be able to sue you for defamation. And in fact, neither will their family or friends or business colleagues or people related to them based on the harm that you did to their reputation. So if you're making a film about real people, focusing on deceased people can be an effective way to protect yourself from potential defamation claims. Number 7, a disclaimer won't necessarily save you from liability. You've probably seen disclaimers at the beginning of narrative films saying something along the lines of, this film is a work of fiction, and any resemblance of any character to any actual person living or dead is purely coincidental. Courts do take language like this into account when deciding whether a statement made in a film is defamatory, but the disclaimer isn't sufficient by itself to completely prevent defamation liability. For example, there was a case in Ohio where a retired family court judge wrote a novel about, surprisingly enough, family court litigation. The plaintiff sued, claiming that he bore a close resemblance to one of the parties who was described in the novel, so the book's portrayal of him could be considered defamatory. The court noted that the author had put a disclaimer in the novel saying that all resemblances between any character in the novel and any live person was coincidental, but the court said that doesn't persuade us completely that the judge couldn't be liable for defamation, because the resemblance between the character in question and the plaintiff was just that obvious. So don't assume that just because you put this disclaimer in the beginning of your film, you're necessarily going to be completely protected against defamation liability. And of course, if you're making a narrative film that's explicitly about real people, or you're making a documentary, you won't be able to make use of this type of disclaimer anyway, because, of course, the resemblance between the characters and actual people in that situation is not coincidental at all. It's what's intended. All that being said, a disclaimer like this is still a good idea, and I would put it in the beginning of your film, because courts are going to take it into account in deciding whether any statement in the film is defamatory. So those are the 7 points that I think it's important for filmmakers to keep in mind when they're trying to plan their shoot and their script and their marketing efforts and so forth to make sure that they don't run into defamation liability. I'm going to cover some other related legal theories in later videos, like misappropriation of name and likeness and invasion of privacy. So stay tuned for that. And thank you for watching.